candle, shine your love to let our children know that we care.
Welcome again, Purpose Family, to another Land Matters with attorney Gloria Brown every Tuesday right here on Caldo Gospel Radio, 7:30 p.m. Jamaica time. God bless you.
Good evening, listeners, and good evening to the Follow Gospel Radio family. Welcome again to Land Matters. And indeed, Land Matters. And I thank those persons who have been listening to Follow Gospel Radio as we try to educate our listeners, not just in relation to Land Matters, but so many of the other offerings that take place on this station. So we invite our listeners to let us become partners in this very, very important and timely radio station. Please remember, if you want to talk to me on anything land related, just send me a text message. If you want to communicate with me, if you have a question, anything in relation to land, buying land, selling land, getting a title for your land, anything land related, probating a will, writing a will, administering an estate, just send me a text message to 876 387 3183, 876 387 3183, as we tune in again to Land Matters on Caldo Gospel Radio. Last week I spoke to you about wills, and just remind you for a few minutes that I said a will must be in writing, so you can't pass your property by word of mouth. So a will must be in writing, must be signed by the person who is making it in the presence of two or more witnesses, and the witnesses should not benefit from the will or the witness's spouse. So you write your will and you ask me to witness it, and you leave a house for me. I'm not supposed to get the house. Everybody else will get what they were bequeathed in the will, but the gift to me will fail. Or you write a will, you leave the house to me, and you ask my husband to witness the will. I'm not going to get the house. The gift will fail. Only a court could say otherwise. So the witnesses should not benefit. When you make your will, you don't have to record it at the Island Records Office, but you can. And you can write a will every day. You can write one in the morning when you get up and another one in the evening. You really should try and date your will, and you need to appoint executors who must be responsible people. And you can have as many as 4 executors. Also, your executors are entitled to 6% of your estate, and that's shared among them. 6%, or you can have one executor, that one will get the 6%. You have 2, they'll get 3%, 3% each, etc. And remember, marriage revokes your will. If you get married, your will has died. Your will is not good again if you should get married. And that is what I spoke to you about last week, and I promised that I would talk to you about this week, intestacy. So when somebody dies leaving a will, we say they died testate. When they die without a will, we say they died intestate. That's intestate. So when you die intestate, you have died without a will. So for example, you make a will today and you get married tomorrow and you die the next day without making another will, you have died without a will. We say you die intestate, or you die and you have never made a will, then you die intestate. And I'm begging Jamaicans, let us start look at the importance of making a will so that we can leave proper legacy to those who are coming behind us. I spoke last week about that I went and did some seminars for teachers who are retiring, and I taught the teachers business. I did a seminar in Mobay, one in Mandeville. That's last month. That's in March. Mobay, Mandeville, St. Mary, that's Galena, and Kingston. And I asked a show of hands for those who had wills, and believe me, it was embarrassing. I don't think 15% of my lovely teachers, okay, could say that they have wills, and that's a cause for concern. So if you die without a will and you have a spouse, the spouse is entitled to your personal estate. So the spouse will get the car, the computer, the jewelry, the clothes, the tools, etc. But the spouse will not automatically get your house, your land, your money, and your business. What will happen to those if you die without a will? And the law says if you die without a will and you have a spouse, okay, and one child, The spouse is to get 2/3 of what you die leaving, and the child is to get 1/3. And remember, in the context of Jamaican law, a spouse is your husband or your wife, or a spouse is a single man living with a single woman for 5 years or more. So if you are not never you're never married, or you got married and your husband has died, or your wife has died, and you're living with another with your partner, and both of you are now single people, and you have lived together for 5 years before your death, that person is your spouse. So the law says if you die without a will, the spouse is to get the personal estate, which are the things I mentioned earlier. The money, the clothes, not the money at all. The clothes, the furniture, the jewelry, the tools. But when it comes to the money, the house, the land, the business, if you have one child, the child is to get 1/3 of what you die leaving, and the spouse must get 2/3. And I must apologize for my dog in the background. If you have 2 or more children and you die without a will, the children must get a half of what you died leaving, and your spouse must get the other half. So you die without a will and you have 10 children and a spouse, the spouse is to get half of what you die leaving, and the children, no matter how many of them, even if it's 40 children, they must share the other half. And remember that if you die without a will and you have children and a child has died before you, the children of that child must get that child's share. So it doesn't work like this where sometimes persons say I'm the only one alive, so I'm entitled. No. Your brothers and sisters' children must get their share if your brothers and sisters have died. So the parents had 10 children, 9 have died, only 1 is alive. The one can't come to me and say, Miss Brown, I'm the only one alive, so the property is mine. No. The one who is alive is entitled to 1/10. The other 9/10 would go to the children of the 9 who have died. If they don't have children, then it will go in the order that I'm going to explain. So this is something that is important for us to understand. So when you make a will, it's governed by a law called the Wills Act, the WILLS Act. That's a piece of legislation. When you die without a will, the law that is governed by is the Intestates, Estates, and Property Charges Act. Under that piece of legislation, what happens is that when a person dies without a will, as I said before, if you have a child and a spouse, the spouse gets 2/3 of what you died leaving, and the child gets 1/3. If you have 2 or more children, the children will get a half, and the spouse will get the other half. Remember, you're listening to Land Matters on Called Out Gospel Radio. And remember that you can send us a message at 876-387-3183. Send me a WhatsApp message if you can. And this station, Called Out Gospel Radio, is a family-driven radio program. And Land Matters is aired every Tuesday at 7:30 p.m. Okay, on Called Gospel Radio, and the radio station is it's stationed in St. Anne, and the aim of the station is to fulfill God's purpose by impacting the lives of persons around us, so that each one can reach one. And we want to welcome our listeners again who are joining us via radio stream on the app in the Google Play Store or any other app on YouTube channel, and we invite you to please communicate with us. If you have a question, you can also send a text message to 876-868-5109 or to 876-387-3183. Send me your messages, anything land related, and I will gladly answer those questions. So if a person dies without a will, let me continue with the table. If a person dies without a will and the person died leaving no spouse, then the children will get everything, or the child that the person died leaving. So no spouse, children benefit. So the only person that children will share with would be spouse. So as long as a person died and left children, then no other relative can put in a claim if the person died without a will. And remember, I'm talking about persons who die intestate without a will. So no spouse, the children will get it, or the child that the dead person had let's suppose the person who died had one child and the child died, but that child died leaving children, then those children will get the share of their parent. If a person dies without a will and does not have a child, but has spouse and parents, the spouse will get two-thirds of what the person died leaving, and the parents will get the other one-third. I'm going to take a break in order to look at a text message. Remember, we are listening to Called Out Gospel Radio, and I invite you to send me your text messages 876-387-3183. My partner and I co-signed on a mortgage through NHD for a land and house construction loan. However, shortly after construction began last year, he went overseas and has since decided not to return. We are now separated. While he continues to pay his portion of the mortgage, he does not contribute to any additional expense that the loan does not cover, and he shows little or no interest in the house. He also has not communicated his intention regarding the property or what he plans to do moving forward. I am seeking advice on the procedure I should take and what options are available to me in this situation. And I think it's important that you do that because you're continuing to spend and you might just be increasing his value in the property. So what I would do if I were you, I would get a lawyer to write to him to ask him what his intentions are, and are you though in a position to buy out his interest? Because the thing with this, is that when it comes to NHD, if you want to buy out his interest or anything like that, you're going to have to make sure that you pay off what he owes under that mortgage. So the money you use to buy out his interest could be used to pay off his portion of the mortgage. Because NHG is not going to allow you to take his name off the title unless the portion that he has under mortgage is covered. So what you need to do is to communicate with him to say, hey, I want to buy out your interest, etc. Because it doesn't make sense that the $10 million house you keep spending on it and it reaches $20 million next year. Okay, also let him know your intention as well, that he's free if he wants to come back, because you don't want him to come to you later on and say you are to pay rent for his half interest that you have been acquiring. So go and get a lawyer to sit down with and let the lawyer deal with it from now. Do not allow it to fester. Also, remember that if both of you are joint tenants and you should pass on, the property is going to go to him alone. And the NHC mortgages are insured. So if one party should die, the mortgage is paid off. So that's something that you need to really, and I'm glad that you are raising it now. Don't allow too much time to pass. Get it sorted out. Because as I said, if you are joint tenants, and remember the tenancy is written on the title, you are either joint tenants or tenants in common. If you are joint tenants, the principle of survivorship operates. So look at the title and see the tenancy. If you are joint and you die, you will get everything, the entire property. Nobody you can tell your children or whoever you have to leave. Because that's the thing with the joint tenancy, the survivor gets it. So it's a good thing that you are not waiting too long and time passes quickly. So don't just allow time to pass by. Go and sort it out. Get your lawyer to get a division of matrimonial property where you can buy them out before the property gets too expensive. And I thank you so much for that question. Please remember the number to send your message, 876-387-3183. 876-387-3183. So anything land related, give me a call, and remember that we're listening to Call Out Gospel Radio, and this station operates outside of Oterios in St. Anne, and the aim of this station is to fulfill God's purpose by impacting the lives of those around us, because we know that how it is in terms of the gospel is that each one reach one. Each one reach one. We are Andrew. Okay, we're like Andrew, who when he saw Jesus went and called his brother. That's the aim of the station, that each one will tell another one about it. Just as when we hear bad news, we run to call others, and before we realize those in America have heard it quicker than those in Jamaica, we want us to spread the good news. Spread the good news about the Called Out Gospel Radio station. Remember, the Bible says, how beautiful are the feet of them that bring good news. So let's bring the good news about the station to those around us so the listenership can continue to increase. And remember, you're welcome to join via the radio stream on the app. in the Google Play Store or any other application. And you can also just go, we're all in tune with YouTube. We can also go onto YouTube and look, even revisit this program afterwards or in order to share on this program. So I was looking at the rule of intestacy, what happens when a person dies without leaving a will. And remember, I just went through what will happen in terms of spouse and children. And I was just touching parents. So if a person dies without a will and does not have a child, but the person has parents and a spouse, then the spouse will get 2/3 of what the person died leaving, and the parents will share the other 1/3. If a person does not have a parents or children, the spouse will get everything. If there is no spouse or children, then the parents will get everything. If you don't have spouse, children, or parents, then your brothers and sisters of the whole blood, that's those who are same mother, same father, will get what you have. So if the person does not have spouse, children, or parents, but they have some half brothers and sisters and some full brothers and sisters, only the full brothers and sisters will get what the person died leaving. And I had a situation like that recently where on a title there's a mother, a son, and a daughter. They are all tenants in common. And when persons are joint tenants, as I said earlier, it means that whoever lives the longest or the longer will get it. When persons are tenants in common, when a person dies as a tenant in common, their share will die with them, so it goes into their estate. So if they don't make a will, their share will be shared according to the table I'm just talking about, spouse, children, parents, etc. So on this title, the mother, daughter, and son are all tenants in common. The mother died and the daughter administered her estate because the mother never had a spouse with the children, so her daughter administered the estate. No, the son has died. The son did not have a wife or children, but the son has half brothers and sisters and full brothers and sisters. So I had to explain to the relatives that the half brothers and sisters have no claim to the estate. Only the full ones, those who are same mother and same father. They are the only ones who can put in a claim in relation to this estate. Please remember the number to text me if you have a question, 876-387-3183. 876-387-3183. Also, of note is that, remember, I just looked at the children, the spouse, the parents, the full brothers and sisters. So if you don't have any of those relatives, then it's the half brothers and sisters who are going to get what you have. Whether you are the same mother or the same father, those are the ones who would be next in line. And remember, I'm talking about when a person dies without a will. If you don't have any of those relatives that I mentioned before, your grandparents will get what you died leaving. So you don't have children, spouse, parents, brothers and sisters, then it's the grandparents will get. If you don't have any of those relatives I've mentioned before, it's your uncles and aunts of the full blood, your mother and father. Full brothers and sisters will get what you died leaving. If you don't have any of those relatives I've just mentioned, then it's your half uncles and aunts, the uncles and aunts of the half blood, we call them. So that's your mother and father, half brothers and sisters will get. So if you don't have children, spouse, parents, brothers and sisters, grandparents, uncles and aunts, then the government will get what you died leaving. So remember, so you realize there's no provision for the nieces and the cousins and the nephews and the grandnieces. So many times I have persons coming to the office to say my aunt died and left, whatever is there, and I want to know how I can get it. And so many times what I see, which is sometimes so unreasonable, is that sometimes the persons who will take care of us, they are not our blood relatives. Okay, but or there are some distant cousin and so on, and those persons' cousins don't fall in line when there's no will. So you are looking after somebody, you are the one responsible for their funeral. Don't let them give you the title before they die, because that is not going to help you. If they have uncles and aunts and half brothers and half sisters, they are going to take the property, whether you have the title or not. They don't need the title to sort out their estate because they can get the title you're holding on to cancelled. So you're looking after a person. Don't let them tell you that nobody going to come and take away the place from you, etc. Let them put provision in place to protect you. Let them put something in place, a will, or to transfer the property to you while they are alive, or add your name to it while they are alive. But don't let persons, whether your spouse or whoever, anybody else, tell you that they're going to take care of you and you mustn't worry because nobody can take away the place from you. Don't take those talk in 2025. If you're doing and you're expending and you're doing all kind of things, let the persons who you are looking after make provision for you. Welcome again to Called Out Gospel Radio, to Land Matters. My name is Gloria Brown. I'm an attorney with office in Kingston, Jamaica. That's in Suite 39, Winchester Business Center and Halfway Tree, and also with an office in Ocherios in the Shop 6 Jamaica National Building. And we'll gladly assist you in anything land related, writing your will, probating the will, administering the estate, getting title for your property. And if you want me to assist you in getting a title for your property, the first thing I want you to do is to survey the property and just send me by WhatsApp the word title. That's all you have to do. Send by WhatsApp to me the word title, and I will gladly guide you on how you are to go about getting that title. When you have that piece of paper, it's very, very important. So I looked at what happens when you don't have the will. And remember, I told you that marriage will revoke your will. If you have a will and you get married, the will is dead. And you die after you made the will and you got married sometime after and you die, you're going to die without a will because the marriage kills your will. Let me use that word instead of revoke. So I can identify, try my best to keep the information simple so that persons can learn and can understand exactly what I'm trying to say. Last week I looked at wills. This week I'm looking at what happens when you don't make a will. When you make a will, you apply for a grant of probate, and the executors do that. When there's no will, you apply for a grant of letters of administration. Sometimes clients come into my office and say, Miss Brown, they say I need a letter, I need letters of administration. You can write the letter for me. So it's not a letter. It's really an order from the court called a grant of administration, or we call it letters of administration. That's an order that the judge signs that gives permission for whoever administers the estate. The judge gives the order in the letters of administration for that person to start sharing the estate, start sharing what the person died and left. So when you get this document called a grant of letters of administration or letters of administration, when the court signs that paper, then you can go to the bank and get the money the person died leaving. You go to an insurance company and get the insurance proceeds. You are able to get the car transferred or whatever motor vehicle there is. You get your name on the title so you can transfer it to the other beneficiaries if there's any other. When you have that piece of paper, you step in the shoes of the dead person. Just as well when the person dies leaving a will, you step in the shoes of the person who has died when you get that probate. That's the same thing. So the probate and the letters of administration, they are really equivalent in terms of their effect. They are the same. They have the same power because both of them, after the court has signed those documents, both documents will give you the power to step in the shoes of the person who has died. So please, that's important to note. Okay, that when you get this piece of paper called letters of administration, you step in the shoes of the dead person. Anything the person who died could do, you are able to do it as well. So a mother died and she died leaving, she didn't have a spouse and she died leaving 10 children. Any of the children can apply for the letters of administration. And it's important to step on it, please, because sometimes those who apply are not those with the best of intentions. And sometimes it's best if 4 of you come together and apply because a maximum of 4 can apply, just as well you can name a maximum of 4 executors. You're listening to Land Matters on Called Out Gospel Radio, operating outside of Ocherios in St. Anne, Jamaica. And remember that Called Out Gospel Radio aims to fulfill God's purpose by impacting the lives of those around us. And you can listen by way of the radio stream on the app or in the Google Play Store or YouTube. You can go and listen to the offerings from the station. And remember, it's not just about land matters. There are so many other activities. There are so many other programs that you can partake of. And remember, you can always send me a text message. Any question you have, you can send me a text message at 876-387-3183, 876-387-3183, and I will gladly assist you in answering any of the questions that you may have. So this week, I spoke to you about intestacy. Remember, when a person dies without a will, we say they die intestate. When a person dies leaving a will, we say they died testate. So this week we're looking at intestacy, and that is governed by the Intestates, Estates, and Property Charges Act. That's the law that governs when a person dies without a will. And we looked at that. Also, I want you to know that, and I will look at next week, maybe if I will look at maybe some of the legislations that we need to bear in mind when we are looking at our estate planning. Because that's one of the things that we're trying to educate our listeners and trying to get persons to plan their estate. Because we can't, as a people, we can't say that we're going to move into become a first world country when we have our estates, our offerings, what we have, the land we have is in such chaos. And I heard Minister Delroy Chuck last week. I read in the newspaper. We were speaking about $60 billion worth of assets tied up in estates in Jamaica. Can you imagine? About 60 billion, I think, is what he said, and I'm going to look back at it. Tied up in estates because if the estates are not administered, they're not in order. So many challenges. So I'm begging my listeners, let us be good stewards and not leave the next generation to be really confused, because this generation that is coming up is not very patient. There are no generation. It's like, they want it no, they want it instant. So it's important that we put things together and ensure that those who come behind us will find us faithful, which is what Called Out Gospel Radio is trying to do in fulfilling its mission. It is trying to ensure that it fulfills the mission that is given to them as stewards, so that those who come behind can find them to be faithful. So I want to say thanks again to Called Gospel Radio, operating outside of Ocho Rios in St. Anne, for this opportunity to share with you on land matters. Please remember that it is required of a steward that a man be found faithful. So we're encouraging our listeners to be faithful in terms of how you deal with this important asset called land, which has been vested in us and which we need to leave for the next generation so that they can be better off, so they can be less distracted, so that they can spend a little more time with things for God and a little less time in struggling and trying to make ends meet. Thanks again to the Cordell Gospel Radio family for entertaining us on Land Matters, and we look forward to sharing with you again, God willing, next week, Tuesday at 7:30 on Land Matters. My name is Gloria Brown. Have a good evening.
Thank you.
My pleasure.